Gabriel Sanchez, nominated to the Ninth Circuit. Samantha Elliott, nominated to the District of New Hampshire. Judge Linda Lopez, nominated to the Southern District of California. Judge Catherine Menendez, nominated to the District of Minnesota. Judge Jinsuk Ota, also nominated to the Southern District of California. And David Urias, I hope I pronounced that correctly, nominated to the District of New Mexico. Today's slate represents a continued effort by the Biden administration and Senate Democrats to advance nominees with the very best credentials, who also bring professional and demographic diversity to our federal courts. It's an impressive group before us today. We have 4 sitting judges with strong records of judicial independence and an even-handed approach to justice. 2 nominees spent a large portion of their careers as federal public defenders, offering a perspective too often missing from the bench. These individuals also have significant experience in litigating in federal court. In addition to their experiential diversity, this slate includes demographic diversity. Judge Lopez would be the only active Latina judge on the U.S. District Court for the Southern District of California, and Judge Ota would be the first AAPI woman to ever sit on that court. A number of our colleagues today are here to introduce nominees, and I look forward to hearing from them. But first, I turn to my ranking member, Chuck Grassley.
Mr. Chairman, I'm going to start out with something that I read, that you had said something about the blue slip process. So if I'm wrong on this, I'll stand corrected after I make my statement. I welcome any response you want to give me. Chairman Durbin said that he was considering getting rid of the district court blue slips for nominees if the objection was not based on the merits of the judge. Instead, there might be a number of exceptions for if a senator declined to return a blue slip because a nominee was a woman, because of sexual orientation, or something similar. I think questioning our colleagues' motives would be a terrible mistake. Democrats refuse to return. Well, I thought we turned. Get that out of here, will you? I turned my telephone off, so I don't know why it's going through my iPad, but it is. You got it turned off?
You throw it in a bucket of water.
Okay. If you'll forgive me, I'm going to start over again. Okay. What?
Go right ahead.
Okay. Before we get to questioning, I'd like to talk about a news report that I recently saw. At an interview, Chairman Durbin said that he was considering getting rid of the district court blue slips for nominees if the objection was not based on the merits of the judge. Instead, there might be a number of exceptions for if a senator declined to return a blue slip because the nominee might be a woman, because of sexual orientation, or something similar. I think questioning our colleagues' motives would be a terrible mistake. Democrats refuse to return blue slips for qualified employees. For example, the senator from New Mexico declined to return blue slip for 3 nominees. We didn't disregard their blue slips. For another nominee, the committee also did not receive a blue slip, and some thought that it was because he expressed his religious beliefs. Catholic bishops even wrote a letter expressing concern, but we didn't disregard the blue slip. California senators also declined to return blue slips for many nominees. Here are just a few: Jeremiah Rosen, Sandy Leal, Adam Braverman, Michelle Pettit. The group of the nominees included a longtime prosecutors, veterans, and a judge. They were all highly qualified, and none of these received a hearing because of our respect for the blue slip process. This would be a very enormous change. It would break down into questioning the motivations of our colleagues, and I don't think the committee should ever take that step. As for the nominees today, I compliment them for being here and wait for the opportunity to ask you a few questions. Now,
Thanks.
You can tell me whether I'm right or wrong.
Thanks, Senator Grassley. And for those who are not aware, the blue slip is the privilege given to senators from the state where the district court is named to decide whether that nomination goes forward. It's an up or down decision. And historically, it has been honored with very few exceptions. But there have been instances where nominees were rejected who were clearly well qualified for the bench for various reasons. It is rare, it is extraordinary, but it happens. And I hope it doesn't happen during this 2-year period. And I hope that we can find common ground. And I am encouraged. Senator Tillis, just the other day, supported nominees for the district court in North Carolina that had been agreed to by a Democratic committee. And Senator Berg supported them as well. That kind of bipartisanship is what I'm looking for. What I want to try to avoid is in some states discrimination against people that is just very blatant and obvious. It would be in the extreme that I would make any exception to this. And I agree with you completely. Deciding what the motive of an individual senator is in a case is a challenge I hope I never have to face. So I think if we continue to work in a bipartisan fashion, as North Carolina demonstrated, that we are going to be able to meet our responsibilities. So at this point,
I would like to make a statement.
Sure, Senator Feinstein, please.
Thank you very much, Mr. Chairman. I want to speak today because the 3 nominees on the federal courts are from California. Gabriel Sanchez has been nominated to serve on the United States Court of Appeals for the 9th. Linda Lopez and Jinsuk Ota have been nominated to serve on the district court for the Southern District of California. I want to point out that these 3 nominees are highly qualified. They are experienced and they are talented, and I believe they will make excellent additions to our federal courts. First, let me just speak for a moment about Gabriel Sanchez. He is currently an Associate Justice on the California Court of Appeals. He received his undergraduate degree from Yale, a master's degree from Cambridge, and his law degree from Yale Law School. After law school, Justice Sanchez served as a law clerk for Judge Richard Paez of the Ninth Circuit. I'm sure that Judge Paez is thrilled that his former law clerk may soon be joining him as a colleague on the bench. Justice Sanchez spent several years in private practice before joining the California Attorney General's office. He then went on to serve as Deputy Legal Affairs Secretary for California Governor Jerry Brown. Governor Brown nominated Justice Sanchez to the California Court of Appeal for the First Appellate District in 2018. Since then, he has established a record of excellence as an appellate judge. That experience, we believe, will serve him well on the 9th. I'm also pleased that the committee is considering 2 qualified nominees, Mr. Chairman, to serve as district court judges from the Southern District of California, Linda Lopez and Jinsuk Ota. Linda Lopez currently serves as a magistrate judge in the Southern District of California, and she is joined today by her husband, Victor, and 3 of her law clerks. Judge Lopez is the daughter of immigrants from Cuba. She was raised in Florida. She received her undergraduate degree from Florida International University and her law degree from the University of Miami School of Law. She spent several years working in private practice in Florida before moving to San Diego. In 2007, she joined the Federal Defenders of San Diego, where she spent 11 years as a federal public defender representing low-income clients. Finally, Jinsuk Ota currently serves as a California Superior Court judge in San Diego. Judge Ota immigrated to the United States at the age of 6, along with her parents, Jung-Sung Lee and Taiwan Lee, both of whom are here with her today. So these are both very qualified nominees, and I'm just delighted that they're before this committee this morning, and I believe the committee will receive them well. So thank you very much.
Thanks, Senator Feinstein. Senator Padilla, would you like to speak at this point?
Yes, thank you, Mr. Chair and Ranking Member Grassley. It's my honor to also help introduce the 3 outstanding and highly qualified nominees from the state of California and welcome them and their loved ones to the Senate Judiciary Committee. Justice Gabriel Sanchez is here today with his wife Christina, his son Conrad, his mother Carmen, and other loved ones. Justice Sanchez is highly respected in California, and he brings thoughtfulness and empathy to every decision that he makes. He was born and raised in Los Angeles, as was I, proud son of a single mother from Mexico who worked tirelessly to make ends meet. With her love and support, Justice Sanchez went on to earn degrees from Yale College, Cambridge University, and Yale Law School. He then began his legal career as a law clerk to Judge Richard Baez on the Ninth Circuit, the same court where he is now nominated to serve. Justice Sanchez then went into private practice, as many young lawyers do, but committed himself to engaging deeply in providing pro bono legal services. So admirably, he earned a Social Justice Award from the ACLU of Southern California for his work representing farm workers, a cause that many, if not all, the members of this committee can appreciate. In a lawsuit to enforce heat illness workplace safety protections. That was the subject of his actions there. Justice Sanchez went on to serve with distinction in California state government, both as a Deputy Attorney General and then as a Deputy Legal Affairs Secretary for Governor Jerry Brown, where he proved himself to be a sharp thinker, a creative problem solver, and a dedicated public servant. In recognition of his work and his even-handed judgment, Governor Brown appointed Justice Sanchez to the California Court of Appeals in 2018. He's earned a reputation as a thoughtful jurist, committed to justice for all, and I'm confident he'll bring the same dedication to the bench on the Ninth Circuit. We also have Judge Jinsuk Ota, who is joined by her husband Jason, her parents, and her sister, and other close friends. At the age of 6, Judge Ota immigrated with her family from South Korea to the United States. She has lived the immigrant experience and what we refer to as the American dream. Through her hard work and dedication, Judge Ota went on to graduate from Yale College and the New York University School of Law. She began her career as a law clerk to Judge Barry Moskowitz, a judge on the Southern District of California, the same judge whose seat she is now nominated to fill. Judge Ota spent nearly 10 years of her career serving in the California Attorney General's office, where she helped to prosecute unfair business practices and protect consumers from fraud. She was known for her dedicated mentorship of younger attorneys, as well as her advocacy for women in the law. In 2020, Judge Ota was appointed to the San Diego Superior Court by Governor Gavin Newsom. And as a family judge, she presides with compassion over some of the most difficult and sensitive matters that come before any court. Judge Ota's empathy is matched by her stellar legal qualifications, and the Southern District will benefit from her service. And finally, Judge Linda Lopez is here, along with her husband Victor, her son Angel, and 3 of her law clerks. Yes, she's originally from Florida, having attended Miami-Dade Community College, Florida International University, and the University of Miami School of Law. After graduating and working in private practice for several years, she saw the light and made her way to California in 2007 and began her tireless service as a federal public defender. Judge Lopez spent more than 10 years as a senior trial attorney for the Federal Defenders of San Diego, where she helped to uphold our constitutional commitment to that every person deserves fair representation, especially when facing the prosecutorial power of the state. She's earned recognition from the Southern District of California for her outstanding community service, and in 2018 was appointed to serve as a federal magistrate judge. Through her work, Judge Lopez demonstrates her legal acumen and commitment to fairness each and every day. In a testament to that fact, she has earned endorsements for her nomination from both federal prosecutors and defenders. As a longtime public defender, Judge Lopez brings a professional background that has too often been missing from our judicial branch. But her perspective, her commitment to equal justice for all will strengthen the Southern District's bench. Colleagues, I urge you to swiftly confirm all three of these highly qualified nominees. Thank you, Mr.
Senator
Chair.
Padilla. Before turning to our visiting Senate dignitaries, we will recognize Senator Klobuchar to introduce Judge Menendez.
Actually, I'll let my colleagues go first. I'm fine. They're
That's
here
very kind.
visiting. We must be kind to our visitors. I think.
What an example you've set. And we're honored to have the Granite State's entire Senate delegation here, 2 former governors, and we'll start with Senator Shaheen.
Well, thank you very much, Chairman Durbin, and thank you, Senator Klobuchar, for allowing us to go before you. And Ranking Member Grassley, I appreciate being before the committee today, and I'm really honored to be here with my colleague, Senator Hassan, to introduce Samantha Elliott, who is the nominee to serve on the District Court for the District of New Hampshire. She's joined today by her husband, Matt, and her son, Henry, and we welcome them as well. And I know that lots of folks are watching and supporting her this morning. Samantha Elliott is eminently qualified to serve on the District Court in New Hampshire. She graduated from Columbia University School of Law, and she's currently an attorney at the Gallagher, Callahan, and Gartrell law firm in our capital city, Concord. Samantha Elliott has litigated before federal and state courts, handling an impressive collection of matters that involve complex areas of the law. Her work has earned her recognition by the legal community and her peers as one of the top performing attorneys in her practice areas. And not only has Samantha excelled in her practice, but she's dedicated her time and efforts to the New Hampshire legal aid community. For 9 years, she served on the joint board of New Hampshire Legal Assistance and the Legal Advice and Referral Center, and she's held various roles on its executive committee. In their letter of support for Samantha's nomination, Deborah Kane Rain and John Tobin, colleagues of Samantha's in New Hampshire who worked with her on these legal assistance positions, spoke glowingly of her commitment to ensuring that everyone has access to justice, no matter their socioeconomic status. They described her efforts for the legal aid community in New Hampshire as immeasurable and marveled at her ability to devote so much time to legal aid while excelling in her private practice. Samantha's tireless dedication to legal aid and exceptional representation in private practice demonstrate her commitment to the principle of equal justice under the law and her skill as a legal practitioner. Her nomination is supported not just by those who know her work on legal aid issues, but by a diverse collection of attorneys and others in the New Hampshire legal community. One of my favorite letters of support came from Chuck Douglas, who is a former Republican representative to Congress and New Hampshire Supreme Court Justice. He's only ever faced Samantha as an adversary in litigation, but he said, and I quote, "She is an excellent lawyer who is creative and diligent and exhibits the highest standards of our profession." Mr. Chairman, I am confident that Samantha Elliott's passion for the law and dedication to the impartial administration of justice would make her an excellent judge. Thank you again for allowing me to appear before the committee today, and I look forward to supporting her nomination when it comes to the floor.
Thanks, Senator Shaheen. Senator Hassan.
Well, thank you, Mr. Chair, and I want to thank you and the ranking member for the courtesy of welcoming us here, and thank you, Senator Klobuchar, for allowing us to go before you. And it's always a real honor to be with my senior senator, Senator Shaheen. It's also a real honor to be here today to join in introducing Samantha Elliott of Concord as the committee considers her nomination to serve on the U.S. District Court for the District of New Hampshire. And I also want to take a moment to thank Ms. Elliott's family, including her husband Matt and her son Henry, for being here today, her daughter and mother, who are unable to join us, but I'm sure are watching. And she's also got a lot of extended family here today who I had the pleasure of meeting. Thanks to her family for supporting her in her work and in this nomination process. Ms. Elliott is an exceptionally qualified candidate to serve in this role. She will bring years of dedicated experience, representing Granite Staters, as well as a passion for justice to the federal bench if she is confirmed. Ms. Elliott has been a leader within the New Hampshire legal community and in our small, tightly knit bar where people really get to know each other. The support and respect that she has is deep and it is palpable. As Senator Shaheen shared, throughout Ms. Elliott's legal practice, she has represented clients at every level of New Hampshire State Court, the U.S. District Court for the District of New Hampshire, and the First Circuit Court of Appeals. Through her work, she has shown a commitment to excellence. She's been selected for inclusion in the Best Lawyers in America, as well as New England Super Lawyers, which are earned as a result of respect and admiration among her peers in the legal field. But even beyond Ms. Elliott's distinct and numerous accomplishments, it is impressive to see the extent to which she has used her professional experience to give back to her community and to her state through the New Hampshire Legal Assistance and Legal Advice Referral Center, which is dedicated to providing legal services to low-income Granite Staters. This year, she became co-chair of the founding board of directors for 603 Legal Aid, another critical resource and legal support system for those in need in our state. Through these dedicated efforts, Ms. Elliott has demonstrated a belief that all people deserve access to equal justice, and her work has helped provide vulnerable individuals in our state with opportunities to receive high-quality legal aid. Just yesterday, the American Bar Association announced that the members of its standing committee unanimously found Ms. Elliott to be well qualified for this role, the ABA's highest rating based on her integrity, professional competence, and judicial temperament. I am likewise confident that Samantha Elliott will be a fair-minded, balanced, and intellectually curious judge with a deep commitment to justice, and she will serve Granite Staters with distinction on the U.S. District Court for the District of New Hampshire. I urge the committee to look favorably upon her nomination, and I look forward to voting for her confirmation when it comes to the floor. Thank you again for allowing me to be part of this process.
Thank you, Senator Hassan. Senator Klobuchar, you're next up, but you can defer again.
We'll again defer. It's wonderful hearing about these judges.
Well,
go ahead.
Let us turn to Senator Heinrich. I believe you were next in line from New Mexico.
Thank you, Chairman Durbin, Ranking Member Grassley, distinguished members of this committee. It is my honor to introduce to you today David Herrera Urias, President Biden's nominee for a vacant seat on the U.S. District Court of New Mexico. Mr. Urias was born in West Texas, but even I will not hold that against him. He was raised and has lived most of his life in Albuquerque, New Mexico, where this district court seat will be based. He attended public schools from elementary to high school on Albuquerque's west side before going to college at the University of New Mexico. Mr. Urias learned the virtues of hard work and honesty from his father, David Sr., who worked for years at a local tire store, and his mother, Estella, who worked at a leather goods factory. His father passed away in 2003 after a long battle with cancer. But Estella still lives in Albuquerque in the house where she and her husband raised their family. When he was 19 years old and working as a busboy at a local restaurant, Mr. Urias met his future wife, Yolanda. They will celebrate their 25th wedding anniversary next spring. I would like to quickly acknowledge Yolanda and their 5 boys, Cristobal, Gabriel, Tomas, Esteban, and Elias, who I am sure are so proud to celebrate his nomination. I was proud to join my colleague, Senator Lujan, in strongly recommending Mr. Urias for this judicial nomination. Over the course of his legal career, he has built an impressive reputation as he has successfully litigated cases before both state and federal courts. After graduating from the University of New Mexico Law School, Mr. Urias served as a judicial clerk to the Honorable Vanessa Ruiz of the District of Columbia Court of Appeals. He then joined the firm Freed, Frank, Harris, Shriver, and Jacobson in New York City, where he practiced corporate and commercial litigation. He also had the privilege of representing families of the victims of the September 11th terrorist attacks. After gaining that valuable experience, Mr. Urias became a staff attorney for the Mexican American Legal Defense and Educational Fund, one of the largest and most prominent Latino legal organizations in our nation. At MALDEF, Mr. Urias practiced cases throughout the Southwest and conducted multiple trials before federal courts. In 2008, he returned home to New Mexico to practice law at the law firm now known as Friedman, Boyd, Hollander, Goldberg, Urias, and Ward. Since 2018, he has been the president of the firm, which handles class action law, civil rights law, criminal defense, and complex civil litigation. Throughout his career, Mr. Urias has served as a mentor and role model for countless junior attorneys. He's been an active member of the UNM Law School community and provided pro bono representation for the most vulnerable in our communities. I am confident that he will continue to a proud legacy of compassionate and committed federal judges in the state of New Mexico. The broad bipartisan letters of support that this committee has received in support of his nomination share that same confidence, and I would encourage all the members of this committee to support his nomination. Thank you.
Thank you, Senator. Senator Lujan?
Chairman Durbin, thank you so very much. Ranking Member Grassley, it's an honor to be with you and members of the committee. And again, I want to thank Senator Klobuchar for her graciousness in allowing us to be able to proceed. To be here with our senior senator from New Mexico, Martin Heinrich, and standing alongside the family of David Urias to serve on the U.S. District Court for the District of New Mexico. Building on the confirmation of Margaret Strickland to the court, the District of New Mexico needs more judges who represent New Mexico, and all we have to offer. Mr. Urias is that judge, and I was proud to join Senator Heinrich in recommending him for this position. David's commitment, experience, and New Mexico roots make him a superb nominee for this vacancy. Importantly, his nomination and eventual confirmation will help ensure the judiciary looks like our state. A public school student, son of working-class parents, Mr. Urias represents the lived experiences of New Mexicans who work hard, achieve success, and apply that dedication to serving others. As an Albuquerque resident, Mr. Urias was born in the West Texas area and made his way to New Mexico at a young age. He received his BA from the University of New Mexico, JD from the University of New Mexico School of Law. Then Mr. Urias then clerked for Judge Vanessa Ruiz on the D.C. Court of Appeals and worked as an associate at Fried, Frank, Harris, Shriver, and Jacobson in New York City. Following his clerkship, he received the prestigious Fried Frank Civil Rights Fellowship, an incredible achievement. But he quickly returned to New Mexico to commit himself to serving others. David's entire career has centered on giving back to the community, representing the diversity of who we are, and advocating for others. Mr. Urias has served as a mentor of new generations of legal minds and hasn't let the cost of legal services stop him from representing those who need representation the most. His family's support and commitment sitting alongside him today, I think, represents the very best of America. President Biden said from day one that he would commit to nominating more qualified and diverse candidates to the courts so that our judicial system begins to reflect the tapestry of America. Mr. Urias' nomination means so much to countless New Mexicans back home, to me, and to Senator Heinrich. Mr. Urias is a highly qualified nominee, and it's my honor to stand with him today to request and urge for a swift vote for his confirmation. And I look forward to supporting Mr. Urias when this gets to the Senate floor. Thank you, Mr. Chairman.
Thank you very much, Senator Lujan. And now what America has been waiting for, Senator Klobuchar to speak to Judge Menendez.
Well, they've been actually waiting for the good news about my introduction about Judge Kate Menendez. And I want to thank you, Senator Durbin, and you, Senator Grassley, for holding this hearing today. Judge Kate Menendez, who's a federal magistrate, is the president's nominee to become a federal district judge for the District of Minnesota. She's supported by both Senator Tina Smith, who had another hearing today, and myself. Judge Menendez is here with her husband, Dan, and her two sons, Riley and Finn. Also watching on TV is her mom, Susan, her brother, Adam, all of whom I know are cheering her on. Judge Menendez is a dedicated public servant with a distinguished career spanning over 2 decades of service. She currently serves, as I noted, as a U.S. Magistrate Judge for the District of Minnesota, a position she's held since 2016. She has earned a reputation for being a fair-minded, insightful, and efficient magistrate that consistently applies precedent of the Federal District Court, Eighth Circuit, and the U.S. Supreme Court. She has presided over hundreds of cases spanning a wide range of civil and criminal matters, and her orders and decisions have been adopted by the judges of the Minnesota Federal District Court, a court which includes judges nominated by Presidents Ford, Reagan, Clinton, Bush, Obama, and Trump. And they have upheld her decisions approximately 97% of the time. In other words, she is ready to serve as a federal district court judge on her very first day on the job. She also will bring to the bench her lifelong dedication to public service. Judge Menendez was born in Emporia, Kansas, and attended Topeka High School. After graduating, she attended the University of Chicago. That was for you, Senator Durbin, where she graduated with honors. Even in college, she demonstrated a commitment to public service. When she wasn't working as a waitress in Hyde Park, she volunteered her time at a women's shelter. She also co-founded an organization dedicated to working with the homeless and was recognized for her work by the University of Chicago, where she was awarded the President's Award for Volunteer Service. She then went to law school, where she served as an editor on one of the law school's journals and graduated magna cum laude. After clerking on the Fourth Circuit Court of Appeals, she began her legal career in public service in Minnesota, working for nearly 20 years representing those who could not afford counsel. During that time, Judge Menendez served as lead counsel or sole counsel in hundreds of district court hearings, argued before the Eighth Circuit Court of Appeals, and appeared before the U.S. Supreme Court not once but twice in her role as assistant federal defender, winning over, this is for you, Senator Grassley, winning over Justice Scalia, who wrote the 8-1 decision in favor of Judge Menendez's client. In addition to her work in the courtroom, Judge Menendez also served as an adjunct professor of law at the University of Minnesota Law School, Hamline University School of Law, and St. Thomas. After she was named Minnesota Lawyer of the Year in 2015, the federal judges on the Minnesota District Court, nominated by both Republican and Democratic presidents, selected her as magistrate. She comes highly recommended to this committee, initially recommended by a judicial selection committee that I convened with Senator Smith, consisting of Minnesota attorneys and judges, and I know that Judge Menendez has support from judges on the Minnesota District Court as well as several on the Eighth Circuit. The ABA Standing Committee on the Federal Judiciary unanimously rated Judge Menendez as well qualified, the highest rating that the committee awards, and based on the review of her professional competence, integrity, and judicial temperament. I believe she'll make an outstanding federal district court judge for the District of Minnesota, and I urge for her swift confirmation. Thank you.
Thank you, Senator Klobuchar. And as you mentioned, your colleague, Senator Tina Smith, has unfortunately a conflict at this time, but she is going to submit a statement for the record in support of Judge Menendez as well. We have one circuit judge nominee, and the others are district court judge nominees. The tradition of the committee is to take the circuit court nominee first, and that would be Judge Sanchez. So, Judge, if you would come forward, please. Before you sit down, I'm going to swear you in with the traditional oath. If you raise your right hand, do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record indicate that the judge answered in the affirmative, as we had hoped. Judge Sanchez, now please take a seat and push the button on the console in front of you so that we can all hear you. And the floor is yours.
Thank you, Chairman Durbin. I would like to thank you and Ranking Member Grassley for convening this hearing and all the members of this committee for considering my nomination. I'm deeply grateful to Senators Feinstein and Padilla for their generous introductory remarks. I would like to thank President Biden for the incredible honor of this nomination. I do not have introductory remarks, but I am proud to introduce my family sitting behind me. First, my mother, Carmen Sanchez. I grew up as an only child to a single mother in Los Angeles, and although we had few means, she was relentless in her pursuit of scholarships and educational opportunities for me. I would not be here today if not for her love and sacrifice. My Aunt Martha Sanchez Warner, one of the first women to attend Yale University, was my inspiration for going to Yale and becoming a lawyer. Next to her is her son and my cousin, Llewellyn Sanchez Warner, who was a virtuoso concert pianist, an incredible talent, and a friend. Next is my 9-year-old son, Conrad Sanchez. I'm so incredibly proud of him and grateful that he begrudgingly agreed to miss his cherished school in Berkeley, California, to join me on this trip. My wife, Christina Meyer. She is the love of my life and has been my best friend for twice as long as we've been married. The luckiest moment of my life was meeting her in the opening days of college. There are many other family members and loved ones who would not be here today but are with us in spirit. I want to briefly mention my mother-in-law, Patricia Meyer, and the Meyer family in the Bay Area. My father-in-law, Jay Meyer, who passed away in 2010. And finally, my grandparents, Juan and Francisca Sanchez, who made the fateful decision to move their family from Mexico to California in the 1960s to pursue their American dream. And I have been blessed by that wise choice ever since then. I look forward to answering your questions. Thank you very much.
Thank you, Judge Sanchez. I'll start the questioning, and then Senator Grassley, Senator Feinstein, and Senator Lee, if he is returned. If not, Senator Kennedy will be recognized. Let me start by saying that it's not uncommon for those to come before the committee who've been involved in some aspect of a political life or in some legal practice to have either worked on issues or taken positions on issues as it, within the practice of law, represented clients who really spoke to a specific issue or set of beliefs. And the questions then asked of the judicial nominee: is this who you are? When cases come before you involving these same issues, what standard are you going to use? We look at your background and say, well, he worked for Governor Brown. He was a legal assistant. He was involved in a lot of propositions and other things. So what does that mean in terms of your philosophy, personal and political, and how it would affect you if you were a circuit judge?
Thank you, Senator. As you mentioned, my policy background involved advocating for different clients and for a good portion of my career for my main client, Governor Brown, and trying to effectuate his policy goals and vision and litigate matters on behalf of many different clients. When I took the role of a judge on the appellate court, I left all that behind. And I understand that being a judge requires being fair and neutral and applying the law fairly to all the parties that come before me. And the way I effectuate that is by making sure that I carefully read the parties' briefs and consider their arguments and consider the governing law and precedent and let those factors determine my judicial decision-making, not anything having to do with my prior policymaking or personal views, because our system of justice depends on a fair and impartial judiciary.
Thank you. I just am going to defer to the other senators who may have questions, and to also say I am touched by your family's immigrant story. There are many of us who have similar stories to tell, and I hope that we never forget the contribution that your family and families just like them have made to this great nation. Senator Grassley?
Yeah. You probably know that things you write in the past become questions for nominees before this committee. So I'm going to go to what you authored, an article discussing the accomplishments of California's newest justice, Joshua Groban. You admired that he placed a high premium on diversity of experience and quote-unquote perspective when vetting potential nominees to the federal judiciary. So how does a judge's perspective, your word, or personal experience inform the judge's interpretation of law, and then whether or not those experiences might conflict with the judge supposed to interpret law and leave personal views out of his case?
Thank you, Senator Grassley. I believe the judiciary and judges in particular are enriched by having a diversity of professional backgrounds and viewpoints. I know that I have benefited from the diversity of backgrounds and perspectives of my colleagues, and it challenges me to keep an open mind and to consider their own perspectives. And so when I wrote that article, it was with that view in mind, that diversity of background, not only democratic diversity, but also professional diversity and different ways of viewing the world can help all of us in the way that we analyze cases. But as you mentioned, and as I had mentioned earlier, the central focus of the judge is to apply the law impartially and fairly. And I try to do that every day with all of my cases by considering their arguments, the limited record before me, the lower court's decision, and those governing precedent and standards, and let that determine the outcome of my decision making.
Okay. I want to go to your work on California Proposition 57, where a large number of criminal defendants were released to the public. Some convicted criminals were released early before the proposition was even passed. Opponents of the proposition cited increasing crime statistics, a 10% increase in violent crime, 37% increase in rape the year before. Do you think the release of convicted violent criminals under Proposition 57 contributed to that increase?
Thank you, Senator. If I may provide a little context for the law, Proposition 57 was passed in response to a federal court order that found that California's prison system was unconstitutionally overcrowded. It was an order that was affirmed by the United States Supreme Court in Brown versus Plata in 2011. And so Governor Brown was faced with the task of complying with the court's order in a way that would ensure that public safety would be protected. And the choice that he faced was either allowing the federal courts to order the outright release of prisoners to achieve that population reduction, or to create a system of parole consideration for nonviolent offenders and sentencing credits that would allow inmates to earn their release from prison. The law itself did not automatically release anyone. What it gave was an opportunity for those to try to prove that they were worthy of release in front of a parole board, or to complete rehabilitative programs to earn an earlier sentence. And in the governor's view, that was the safer way to approach the problem that we had to face, rather than indiscriminate releases by the courts.
Okay. I'd like to have you talk about your trial experience, specifically your criminal trial experience. How many criminal trials have you personally appeared in court for, and explain that role?
In litigation at my private law firm, I was involved in one criminal defense, and it was in state court, and that was at the early stage of that process through the preliminary hearing. And then the matter was stayed as we petitioned for review before the California Supreme Court. I do not have a great deal of criminal trial experience, but in my role in the state government, I had to deal with many criminal issues and corrections issues over the course of many years. And as an appellate justice, fully half of my caseload of the 490 or so cases that I've issued or joined have involved criminal appeals, and have had to develop a deep knowledge base on those issues.
Thank you for your answers.
Thank you.
Senator Feinstein?
Along those lines, if I might, Justice Sanchez, you were appointed by Governor Jerry Brown to serve on the California Court of Appeal for the First Appellate District in 2018. You've been very active on that court during the last 3 years. I noted in reviewing your experience that you have filed or joined in nearly 500 opinions during your time as a state appellate judge. So here's the question. How do you believe your experience serving as a state appellate judge on the California Court of Appeal has helped to prepare you for a federal appellate judge if you are confirmed to the Ninth Circuit? And what kind of a judge would you strive to be?
Thank you, Senator Feinstein. I have addressed a wide range of state and federal legal issues in the cases that have come before me. And as you said, I authored or joined in nearly 500 opinions on a wide range of matters, from civil, criminal, statutory and constitutional interpretation, administrative reviews, environmental reviews. And I believe that that skill set and those experiences would translate to the federal appellate court if confirmed. I love delving into new areas of law and wrapping my arms around complex factual and legal matters, and the back and forth with counsel and keeping flexibility in my way of thinking before I determine what I believe is the right outcome. And I would take those concepts, those guideposts with me if I were to be confirmed on the Federal Court of Appeal.
Well, let's speak for a moment about those guideposts. You've been very active on the Court of Appeal during the last 3 years. I noted in reviewing your experience that you have filed or joined in nearly 500 opinions during your time as a state appellate judge. So how do you believe that your experience serving as a state appellate judge on this Court of Appeal has helped to prepare you to serve as a federal appellate judge? What will the people of California be getting in terms of you reflecting your background?
Senator, they will be getting a judge that takes his oath of office very seriously and approaching each case individually with a fair perspective for both sides. I try very hard not to bring in any preconceptions or to reserve judgment as I read the parties' briefs and consider their arguments and research the applicable law and the governing standards. And those processes that I apply today as an appellate justice, I would apply as a federal appellate court judge. And ultimately, when I render a decision to write an opinion that is provides a clear basis of my decision and clarity to the parties that came before me and to the lower courts for them to follow.
Thank you. Thank you, Mr. Chairman.
Thank you.
Thanks, Senator. Senator Kennedy, do you wish to ask?
I do. Mr. Chairman, thank you.
You're recognized.
Thank you, sir. Judge, congratulations.
Thank you.
I'm not going to ask you to comment on precedents or cases of the Supreme Court. Is that okay with you?
Okay.
Good. I just want to try to understand the way you think and what your beliefs are. When, in your opinion, does life begin?
Well, Senator, from my reading of Supreme Court precedent.
No, sir, I'm not interested in the law. I'm interested in you. When, in your opinion, does life begin? You can't hear me? Can you hear me now?
And we want to.
You want me to start over?
No.
Well, I just used 20 seconds. I want you to add 20 seconds to my... Let me ask the
Order.
question again. When, in your opinion, does life begin?
Well, Senator, I don't believe my own personal views enter into the picture
I know,
as a
I
judge.
understand that you're going to follow precedent. I'm just asking you, I want to get to know you. You're going to be on the Court of Appeal if you're confirmed. When, in your opinion, does life begin?
And so what I was explaining is whatever my personal views on those areas, I do set them to one side because
I understand that, but I'm trying to understand what those opinions are. Are you going to answer my question?
Well, in answering, I would not want to give the impression that I'm prejudging a situation
I'll stipulate you're not prejudging.
or allowing my own personal views
I'll
to
stipulate
pervade
that.
into. And so, well, Senator, respectfully.
Have you thought about it?
About when life begins?
Yeah.
Yes.
And what did you conclude?
I conclude that as a judicial nominee and a sitting judge, I would not want those views to weigh into how I approach cases, and I would follow Supreme Court precedent
All right.
and its guiding
All
precedent.
right, I get it. Let me ask you your thoughts on another subject. Biologically, how many sexes are there?
As I understand it, there are different views on that topic.
I'm asking you your view.
Again, that is an area that I believe could come before me as an issue, as it has come recently.
I'm not asking about a case. I'm asking about you. Biologically, in your opinion, as a thinking adult, how many sexes are there?
Senator, as I said before, my own personal views, I don't want them to enter into my role as a judge. And so if I were to be faced with an issue where a person's sex or gender came before me, I would apply that Supreme Court precedent
Right.
and consider it in the
We
context
stipulated
of...
to that. We stipulated to that. I'm asking you personally, biologically, how many sexes are there in your opinion?
I would give the same answer as before, where I would not want to give an answer of my personal view and give the impression that I'm prejudging an issue myself.
Okay. Have you thought about it?
I have.
Okay. What was your conclusion?
That it is a matter of importance and debate in our society today. And while I have my own personal views about it, my role as a judge is to apply the law and precedent and let the arguments and facts speak for themselves.
All right. In your opinion, is the California Court of Appeals systemically racist?
Senator, I have not had occasion to consider whether a court system is systemically racist as a court. As a general matter, I believe judges take their oath of office very seriously and try
I
to
agree with
consider.
that, but what about the California Court of Appeal? Is it systemically racist?
As I said, if the issue of systemic racism were to come in, I would consider it within the context of whatever the arguments are.
Have you thought about it?
As a private citizen, as a general matter, I know that systemic racism is a topic of discussion.
Okay, so is the Court of Appeal, in your opinion, on which you sit, systemically racist?
I believe that the judges in which serve on the Court of Appeal or the Supreme Court try to handle
Answer my questions.
their cases.
Why won't you answer my questions, Judge?
I'm sorry, Senator.
Here's my final one. What's your favorite color?
Blue.
Good. That was easy. I don't understand why you won't answer my questions. And you're not the first nominee that has come forward that refuses to answer a single question in 5 minutes. How can I vote for you if you won't answer my questions?
Well, Senator, if systemic racism were a matter that came before me,
I didn't ask that. I stipulated that wasn't going to be the case. I'm just asking your opinion. You sit on the bench. You think it's systemically racist. But I do understand your favorite color, and I appreciate that. Thank you, Mr. Chairman.
Thank you, Senator Lee.
Thank you, Mr. Chairman. I thought you were calling him Senator Lee for a minute. I was about to introduce myself. Thanks for being here. You've been on the California Court of Appeals now since 2018, so about 3 years, going on 4 perhaps. How are under the Constitution of the state of California, how are the justiciability rules different under the California Constitution than under the federal system? Do you have the same concept of Article 3 justiciability?
Thank you, Senator Lee. As I think about it, I think the rules of justiciability generally pattern after the federal rules, within the California state system, right, and are considered in similar ways.
Right. You're familiar with Article 3 justiciability. What are the elements of them? Of Article 3 justiciability? What do you have to have a justiciable case in federal court?
Are you referring to standing itself? Or?
Yeah, standing, ripeness, mootness,
Sure.
Every element of it.
Sure. Well, for standing, under the Lujan, Supreme Court's case in Lujan, a claimant has to have an injury in fact, a legal injury that is concrete and particularized, as well as some sort of causal connection between the claimed misconduct and the injury, and finally, that it's likely to be redressed. And ripeness occurs when a court decides whether the matter should be heard at a particular time. And there's a related doctrine of mootness. If something is heard that would render a court's decision to be advisory, or whether there's a likely to have a recurrence in the case before you.
In federal court, when is there subject matter jurisdiction over a case in federal court?
Subject matter jurisdiction would occur, Senator, if it's a question of federal law, whether it's statutory or constitutional, or if it comes up under diversity jurisdiction between citizens of different states.
Can that ever be waived?
I'm sorry?
Can that be waived?
No. Subject matter jurisdiction is a requirement of entering to federal court.
Under what circumstances should a federal court apply state law?
Federal court should apply state law when they're sitting in diversity. And also, if there are ancillary state issues within a federal case, the federal court might, as a discretionary matter, take on those ancillary state issues along with the federal claims that it's considering.
What about federal common law?
Federal common law, as I understand it, applies in a narrow, not frequently. There may be federal procedural issues that come up under federal common law, but it's very limited.
How now you clerked for a federal judge on the court to which you've now been nominated, Judge Paez. Would you identify Judge Paez as one who would be a judicial role model of sorts?
I would.
And how would you describe your judicial philosophy?
My judicial philosophy is to give, to apply each case fairly and neutrally, and to allow the parties to have that sense that they have a fair stake in arguing their own sides, and that I will apply to each matter a thoughtful and neutral approach to deciding their issues.
How about statutory construction? What's your approach to construing the meaning of a federal statute?
The Supreme Court has guided lower courts to look first at the statutory provision itself in the context of the purpose and overall structure of the statutory scheme. So I would look to the plain language of the text of the statute as the starting point of analysis to discern what legislative intent should be.
When would that starting point not also be the finishing point?
If there's ambiguity in the statutory text, or ambiguity in the way that the text is written in the context of the purpose and overall structure of the statute, then there may be other tools to also look to try to have a more confirming sense of what Congress intended.
What about discerning the subjective intent of a Congress in enacting legislation? Assume, for purposes of our discussion, we're talking about text as to which there's an ambiguity. How do you ascertain Congress's intent subjectively?
Well, the Supreme Court has said to look at committee reports as a source of legislative history, but the court has also cautioned lower courts that stray remarks or individual comments by a senator shouldn't be overblown in a sense or taken to encompass congressional intent.
How could one meaningfully differentiate a committee report, which may reflect the views only of the author, who may not even be a member, from stray remarks made by a legislator on the floor in committee?
Well, I would say, Senator, that it's in the context of whatever is being read. And if it's a stray remark that only happens once or in an isolated instance, I don't think that stray remark would be given any weight. As opposed to if the statements.
What if there are 10 lawmakers who all say the same thing?
There may be a little more weight to that, but as I said, that legislative analysis is done in the context of what the statutory text itself says and the purpose of the statute. And so really the driving force behind that analysis tends to be more in those earlier factors than legislative history itself.
I see my time has expired. Thank you, Mr. Chairman.
Thanks, Senator Lee. Senator Cruz, you're the remaining senator to ask if you wish.
Thank you, Mr. Chairman. Judge Sanchez, you played an instrumental role in drafting and implementing Proposition 57. You were an advisor to Governor Brown. You were an author of the bill, and you helped craft and coordinate messaging in favor of the measure. Opponents of Proposition 57 at the time warned that you and other authors were not telling the truth, were not being candid about the effect of that proposition. They said it would apply to violent criminals, such as rapists when their victim is drugged, to human sex traffickers, to those who committed hate crimes, and to others whom the average person would not consider nonviolent. At the time of the drafting, was your intent to make those individuals eligible for parole?
Well, thank you, Senator, for that question. As I said before, as I mentioned earlier, the law itself did not automatically release any individual. It only provided parole consideration for nonviolent offenders and a sentencing scheme, a system of sentencing credits for rehabilitative programs. The Proposition 57 and the implementing regulations did not define who was a violent or a nonviolent offender. That was made by reference to existing California Penal Code. And the intent in the passage of that law was to allow those parole consideration in order to comply with the federal court order that California reduce its prison population to a constitutionally tolerable level.
Okay, so let me try again on that question. Let's take them one at a time. Let's take rapists when their victim is drugged. Was it your intent that a rapist who had drugged his victim should be eligible for parole?
Well, let me start by saying, Senator, I worked for Governor Brown as a staff member, and so I worked to effectuate his policy goals.
So did you disagree with him on Proposition 57?
No,
Okay, well then let me ask you again. You played a leading role in this. If you want to disagree with it and say, hey, the governor was wrong and I was following orders, that's one thing. But if you're not going to say that, then I'm going to return to my question. Was it your intent? And let's take the first example I gave. Rapists who drugged their victims. Was it your intent that that rapist should be eligible for parole?
Governor Brown's intent was in complying with the federal court order.
Let me focus on your intent because you're the one nominated for a lifetime appointment to the Court of Appeals.
My intent was in serving the governor's policy vision and goals, and the overall purpose of the law was to respond to a federal court order that had been affirmed by the U.S. Supreme Court.
Okay, so let me try it again. Let's ask a different question. How about human sex traffickers? Was it your intention, as one of the leading drafters, that human sex traffickers should be eligible for parole?
The intent of the law was to provide parole consideration for nonviolent offenders as defined by existing California Penal Code.
Do you dispute that human sex traffickers would be eligible for parole under it?
If whatever crime was defined as nonviolent under the California Penal Code...
Would human sex traffickers qualify, yes or no?
I believe sex trafficking... Well, I would reference the California Penal Code to determine whether that was a violent or a nonviolent category of crime.
All right, how about those who have committed hate crimes?
As I sit here today, I'm not aware in which side hate crimes fall under. There can be circumstances
So you
where...
didn't spend a lot of time focused on that question?
No, what I would say is that with any of these categories, I would follow California, or what we did was follow California Penal Code as to define who was a violent or nonviolent offender.
So several reports indicate that violent criminals have been subject to parole. Likely criminals that the unsuspecting public did not intend on releasing when they passed Proposition 57. Sex offenders, gang members, batterers of police officers have been made subject to parole. As a result of your direct efforts, violent criminals were paroled, and California was made less safe. I guess my question is, did you intend for violent criminals to be released early? or were you simply unaware of the consequences of your action? Which one was it? Did you know what you were doing, or did you not know what you were doing?
Thank you, Senator. The intention of the law was to comply with that federal court order, and the choice that Governor Brown faced was
I'm not asking about the governor. The governor has not been nominated to the Ninth Circuit. You have. So I'm interested in a litigant who would appear before you, who might very well be troubled about a judge who is soft on crime, who wants violent criminals, who is fine with violent criminals being released early. That would trouble a great many litigants. I think that would trouble a great many Californians who believed that this proposition was not affecting violent criminals when in fact it was. And so my question is what was your intention, not Governor Brown's, not anybody else, your intention, and were you aware of what you were doing? Did you know violent criminals would be released early when you were helping lead the efforts to pass this proposition?
As I mentioned earlier, the law, the choice that was faced was between allowing federal courts to order the outright releases of prisoners without any sort of rehabilitation efforts, or to create a system of parole consideration and sentencing credits to address an order that the United States Supreme Court had affirmed. And in the governor,
my time has expired, but let me just try one final time. Were you aware violent criminals would be released early under this? Yes or no?
Senator, we were aware at the governor's direction that it would affect the entire population of the prison system, hopefully to get people to rehabilitate and to improve their lives before.
That sounds like a yes. Thank you.
Senator from Texas, time has expired. Senator from Tennessee.
Thank you, Mr. Chairman. I appreciate that. And Justice Sanchez, thank you for coming before us today. A timely question for you. Do you believe that the right to keep and bear and own arms is a civil right?
Senator, under Heller, it is the right to keep and bear arms is a constitutional right that all citizens possess.
Do you support the Second Amendment?
Senator, I support all amendments, all express rights that are in the Bill of Rights, and rights that are recognized by the United States Supreme Court.
Okay. Let's talk about this, continuing with California Proposition 57. There are a lot of Californians that are moving to Tennessee. One of the reasons that they cite for leaving the state are very high taxes, and another is a whole lot of crime. And the way crime on the streets has changed so many of the communities. Now, I know you didn't want to answer Senator Cruz's question, but let me come at it a different way. Because when you look at the work that you have done on this, talk to me about what guides your judicial philosophy on sentencing.
Okay, thank you, Senator. Yeah. My policymaking past is just that. I served as a staff member for Governor Brown, working to effectuate his policy goals.
Now, what principles guide you? What is the purpose of punishment? Because, see, you've just talked about you knew there were people that were going to be released. You were hopeful people were going to go through rehab. But then you kind of contradict yourself. So why don't we do this? Why don't you just submit for the record what your philosophy is on sentencing and what you think is the purpose of incarceration, the purpose of punishment? Because I don't know of anybody. I talk to people that have moved out of California every single day, and they are so frustrated with the way the state is being run. And so they're choosing to leave. Let me move on to People versus Silas and ask you about that. Now, I understand that involved a preemptory strike on a prospective black juror, correct?
Yes.
Okay. And as I understand it, the prosecution exercised a preemptory strike against a black juror who expressed support for Black Lives Matter, citing the juror's hostility when asked about BLM. And you issued a decision that suggested that the prosecutor's preemptory strike was actually motivated by discriminatory intent based on the juror's race. And I would like to know more about your thinking in that case, because it seems to me, as I looked at it, that you're conflating support for BLM, which says that they are a trained Marxist leaders in this group, that you're equating that with race. So why don't you talk just a touch about that? We've got a limited time here.
Thank you, Senator. As you mentioned, the claim was brought under Batson versus Kentucky, in which the Supreme Court held that use of a peremptory challenge by the prosecution to excuse a juror on the basis of race violates the Equal Protection Clause. On review of that appeal, we looked at the three-part analysis of whether the plaintiff had made a prima facie case of discriminatory intent. And in that case, the questioning was conceded by the Attorney General to have been inappropriate with regard to the Black Lives Matter movement. But there were other indicia in the record as well of evidence of a discriminatory motive. For example, the prosecutor's explanation for excusing the juror involved that the potential juror was late, when in fact it was a different African-American juror that had been late. And there were other aspects of the record that supported an indicia that the prosecutor was substantially motivated, at least in part, by a discriminatory purpose.
Okay.
It wasn't only Black Lives Matter, but that played a big role in the case.
Okay, thank you for that. Demand Justice is a far-left group that is supporting your nomination, and you've expressed preference for, and I'm quoting, diversity of experience and perspective in the courts. And in light of this, I would like for you to define what you see as being appropriate action on the bench and judicial activism.
Thank you, Senator. Judicial activism to me means when a judge allows their personal viewpoints or policy perspectives to pervade their decision-making. It is not an appropriate thing for any judge to do. A judge should consider the court, the party's arguments, the lower court's decision, and the governing law.
But Demand Justice likes activist judges, and they're supporting you. So do you agree with their philosophies?
Senator, I'm not familiar with Demand Justice's philosophies. I can only speak to how I approach each individual case that comes before me.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Senator Tillis, do you have any questions of this witness? Okay. Judge Sanchez, thanks for being here today. There may be some written questions sent your way. If you could respond to those in a timely way, we'd appreciate it.
Thank you, Chairman.
Thank you. So we're on a roll call on the floor, which is going to mean that we have to take a break here as we set up for the second panel. So I hope you'll forgive us, but we didn't anticipate that we would run into that. We'll be back in just a few minutes, perhaps 10, and resume the hearing. We'll stand in recess. its consideration, and I would say for the record that that was a foot race between Senator Blackburn and myself, and she had to go to her office first, but it ended up in a tie, but we're leaning toward giving her the trophy because she did it in high heels. So we thank her, like Ginger Rogers, for extraordinary performance. Welcome to the second panel, and I'd ask you each to stand as we administer the oath. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Every one of the panelists answered in the affirmative, so we can now proceed. You each have 5 minutes, and according to my list, the first up is Miss Elliott. You need to activate the microphone. There we go.
Thank you. I hope I've set an example for the rest. First, I'd like to thank Senator Shaheen and Senator Hassan for their generous introductions and for recommending me to the President. Thank you to Chair Durbin and Ranking Member Grassley for convening this hearing and to all the members of the committee for considering my nomination. I'm truly thankful to President Biden for the greatest honor of this nomination to the District Court of New Hampshire. I'm lucky to have many family members in attendance, but I'd like to first acknowledge my family, friends, and colleagues who are not here. My mother, Judy Campbell, who's inspired me by example and taught me that the secret to a good life is to work hard and smile easily. To my grandmother, Phyllis Campbell, and my stepmother, Susan Dumais, whose love and support has meant so much to me. My colleagues at Gallagher, Callahan, and Gartrell, where I've spent my entire career, who have played such a big part in fostering my love for the law. With me is my sister, Christine Preston, and her husband, Michael Preston, who have traveled here from Madison, New Jersey, to support me. I've always been moved by their commitment to the public interest. My parents-in-law, Tom and Sally Elliott from Spotsylvania, Virginia, who've been the best cheerleaders. My brother-in-law, Michael Elliott, with whom I've had the privilege to attend both college and law school, so it only seemed fitting to have him here with me today. Behind me is my son, Henry, 13, whose love of history, I hope, will keep him awake and alert while we answer your questions. My daughter, Fiona, 16, is learning about the world by finishing her final 2 years in high school, studying in Norway, so she understandably could not make the trip. And last but not least, my husband, Matt Elliott, who specifically requested to be introduced to you as my rock. But in all reality, nothing I've ever done in the past 26 years would have been possible without his support. And the sheer number of oral arguments he's had to sit through while I practiced has earned him the honor of that title. Again, I'm beyond grateful, and I look forward to answering any questions you might have.
Thank you very much. Ms. Lopez?
Good morning. Thank you, Chairman Durbin and Ranking Member Grassley, for scheduling this hearing. Senators Feinstein and Senator Padilla, I thank them so much for their kind introduction and for their support. I'd like to thank President Biden for the honor of this nomination. I am truly humbled. And to the esteemed members of this committee, I thank you for your consideration. I grew up in a working-class neighborhood in South Florida. My brother, my sister, and I were taught the importance of hard work, kindness, determination, and honesty. These were the cornerstones of our upbringing. When I was 11 years old, I lost my mom. While my father faced many challenges raising 3 young children on his own, he made certain that we knew we were loved and protected and reminded us often of the importance of hard work, kindness, determination, and honesty. While neither of them are here with me today, I know they are in spirit. The lessons that they have taught me have served me well. By living my life adhering to these core principles, I have in turn been blessed with wonderful friends, colleagues, and mentors. Too many to mention here this morning, but all who have helped me become a better woman, wife, mother, lawyer, and judge. My children, Riley and Angel, are so proud of me. I know they're rooting for me. And my brother, Robert, my sister, Ida, and their respective families are back in Miami, extremely excited and proud that I am here before each of you. With me today is my husband, Victor, who has been my greatest friend, husband, and a fantastic father. I could not be here without his support. Also with me are my law clerks, Felicia, Ami, and Spencer. I appreciate each of you so very much. I try to tell you often, but please know how much you all mean to me. To my entire court family back in San Diego and all of my friends who have offered their support, I am very blessed to be here. Senators, I look forward to any questions.
Thank you very much, Judge Menendez.
Thank you. It's an honor to be here, Chair Durbin, and thank you for convening this hearing, as well as thanks to Ranking Member Grassley. Enormous appreciation to Senator Klobuchar for the humbling introduction, and to Senators Klobuchar and Smith for supporting my nomination, and to President Biden for showing faith in me by nominating me to this important position, and for the Judicial Selection Committee convened by the senators that recommended me. I'd like to acknowledge my family that's here with me today, my husband, Dan Rogan, and my sons, Riley and Finn. My husband has been my biggest champion and cheerleader throughout my career, and I wouldn't be here today without him. I'd also like to acknowledge my mom, Susan Ireland, who always taught me the importance of public service from the time I was a little kid, and my brother, Adam Menendez. They're watching and cheering from the West Coast. And lastly, to all the Rogans out there in Minnesota who are also enormous supporters. I am humbled to be among such impressive co-panelists. I was wowed when I heard their introductions this morning, and I'm very honored to have been nominated to have a seat on the District Court of the District of Minnesota. I practiced in front of this district court for more than 18 years. I was chosen by this district court to be a magistrate judge, where I've served for 5.5 years, and it would be the honor of a lifetime to take a seat among them. Thank you.
Thanks, Judge. Judge Ota? Is the microphone on? There we go.
Thank you, Chairman Durbin and Ranking Member Grassley and the senators of this committee. I'd also like to thank Senators Padilla and Feinstein for the kind introduction and placing their confidence in me. And thank you, President Biden, for the deep honor of this nomination. When I was 6 years old, I immigrated from South Korea with my parents, Taewon Lee and Jung-soon Lee, who are sitting behind me, and my sister, Jin-sun Lee. My parents lived hard immigrant lives where they struggled with the language so that I could have these opportunities. And every day they showed me an example of what uncomplaining hard work and courage in the face of daily obstacles looks like. So I'm deeply gratified, grateful, and honored by this nomination that reaffirms their choices, their sacrifices, and their deep faith in this great country. Thank you to the judges of the San Diego Superior Court who are covering my courtroom so I could be in Washington, D.C. this week. And a special thank you to Judge Barry Ted Moskowitz of the Southern District of California. I clerked for him for 2 years, but his example, his mentorship, his guidance has buoyed me and sustained me for the past 20 years. Finally, I owe more than I can express to the unwavering love and support of my family, my friends and team who are represented here today by Leslie Park and Devin Money, my parents-in-law, Helen and Douglas Oda, who are watching my children at home, and especially my husband, Jason Ota, who is here with me, and my 2 sons who are supporting me from back in San Diego, California. I look forward to answering your questions.
Thank you. Mr. Arias?
Thank you, Chairman Durbin, Ranking Member Grassley, all the members of this committee for inviting me today to this hearing to consider my nomination to be a federal district court judge for the District of New Mexico. I also want to thank both of the outstanding senators from the great state of New Mexico, Senator Heinrich and Senator Ben Ray Lujan, for their kind words and their warm introduction this morning. I would also especially like to thank President Biden for the nomination, which has been the greatest honor that I have received in my legal career. I'd also like to introduce some of the very important people in my life who have supported me not only through this process, but through my entire life, starting first with those who could not be here today. My mom, Estela Herrera Urias, who taught me right from wrong, taught me just about everything that I know, really, been my guiding light since the time I was born, and who consistently drives me to be a better person. I'm sure right now my mom is sitting somewhere in front of a computer in New Mexico trying to figure out how to watch this live, and I hope that somebody is helping her with that. I also want to thank my father, David Urias, who's watching today from above, and who, along with my mom, instilled in me a sense of strong family values and faith, and who always encouraged me to better myself and reach for those goals, even those that seemed unattainable. Also watching today from New Mexico is my sister, Gina Sandoval, and watching from the state of Washington is my brother, Robert Urias, I want to thank them both for being such a huge part of my life and for unwavering support and love. Present with me today are a few people, members of my immediate family first, what I call my gaggle of sons. There's 5 of them behind me, Cristobal, Gabriel, and Tomas. My nephews, whom I've been raising since they were young boys and who I consider to be my sons, Esteban and Elias. If you look back there, they're all in matching gray suits, and they all look better than I've ever seen them look before, so I'm very proud of them. All of these boys are the pride of my life, and I cannot understate how important it is that they are here. Although I do have to tell them that I expect them to make up their schoolwork when they get back to New Mexico. Also sitting behind me is the love of my life, my wife, Yolanda. I think she's 2 rows back. We have been married now for almost 25 years, and I really owe everything that I am and all that I will be to her. I want to thank her for her enduring love and partnership. Present today also are 3 dear friends of mine, starting first with Michael Aguilar, who is my cousin and my best friend. We've been raised together since we were small kids. He traveled all the way from Rio Rancho, New Mexico to attend today. My friend and former work colleague, David Hinojosa, who hails from San Antonio but is now doing great work with the Lawyers Committee on Civil Rights here in D.C., and the Honorable Vanessa Ruiz of the District of Columbia Court of Appeals, who I clerked for almost 20 years ago, and who taught me what it means to be a good lawyer, really, and by example, what it means to be a fair, impartial, and just judge. I thank all of these important people for their support, and I look forward to the questions.
Thank you, Mr. Arias, and I want to thank each and every one of you and your families for being with you at this important day in your lives. Each one of these nominees has been rated well qualified by the American Bar Association. Congratulations. That speaks to your competence and honesty. Your peers have reached that conclusion, and that isn't always the case with nominees before this committee in previous years. But the senators have worked with President Biden to make certain that each nominee that has come through here this year has at least reached this standard. So my congratulations to you. I also, since all of you sat through Judge Sanchez' previous panel questioning, you realize that if you want to aspire to be a judge at some point in your life, you should not write a letter to the editor when you're in college. Or do anything else that might get you in trouble 20 or 30 years later. In all honesty, that is the world that we live in as politicians, and that world is being superimposed on judicial nominees to have them explain things that they did not think were that important in their life, but turn out to be very important in the eyes of the senators. So many years ago, before I got actively engaged in politics, I practiced law in the Central District of Illinois. And appeared before federal judges and had cases in federal court. And I quickly realized that most of the judges knew the law and certainly applied it as best they could. But there was such a difference in temperament with these judges. There were some that I thought were the best of the best, and others not so. I'd like to ask you about the question of temperament. I'm going to ask you a more specific question. You've all worked with judges and appeared before them. If you could think of an example, name the judge if you wish, of a demonstration of good temperament in a case that you've been involved in a court, wish you'd share it with us. Ms. Elliott?
Thank you, Chair Durbin. You're putting me on the spot to ask me to select only one judge. I've had the good fortune of practicing in New Hampshire in both state and federal courts over the course of 15 years and hundreds of clients, and I've appeared before a number of judges. I think the most important qualities that I've seen in a judge for temperament are humility and humanity. Humility to understand their limited role and to set aside their personal views, and humanity to treat all parties who appear before them equally. And there are some judges, many judges in the federal court that I could name, but I think you'll understand that I don't want to name any of them right now. I don't want to single anyone out. But I can name one person you wouldn't have heard of, but there was a Superior Court judge in New Hampshire named Kenny McHugh. He's since been retired. And every person who appeared in his court knew they were welcome there. He didn't stand on formality, and his biggest aim was to make sure that the parties understood what was going on and could explain their case to the judge. They had that opportunity to explain their case to the judge in whatever words worked for them, and he would take it seriously. And I think that that's the inspiration that I would hope to follow if I had the honor of being confirmed.
Thanks. Judge Lopez?
Thank you, Chairman Durbin. I have to agree with just about everything Ms. Elliott said, and I would add that I have found, as a sitting judge now, that walking into that courtroom with patience and being willing to listen to the arguments is something that all parties appreciate. Every day that someone walks in court, it might be my job, but it is their big day in court. And as long as they feel that the judge is attentive and listening and patient, that person feels like they had their fair day in court.
Thank you. Judge Menendez?
Thank you, Senator. Having appeared in front of so many judges over and over again, I've seen them show great compassion and patience and even-handedness in difficult circumstances, and I've taken lessons from each of the judges that I've appeared in front of. I'd also briefly name the judge that I clerked for, a judge on the Fourth Circuit who has passed away, Sam Irvin. He was one of the most humble people I ever met, and he really embodied the idea of never to get too big for your britches, and I hope that I have brought that same humility to the bench. Thank you.
Judge Ota?
Thank you. I've already mentioned Judge Moskowitz, who has been my mentor and my example for so many things. As his clerk, I saw firsthand just how kindly, with humility, with generosity of spirit, that he treated every single person that appeared in his courtroom, and every day as a sitting judge, I seek to emulate him.
Thank you. Mr. Urias?
Thank you, Chairman Durbin. I would say that as far as temperament is concerned, I think I started learning that about judges and how important it is to have a good temperament when you are a judge. When I clerked for Judge Ruiz here in the District of Columbia Court of Appeals, that continued on throughout my career. I've practiced in federal courts in Northern District of Texas and the Southern District of Texas and Arizona and New Mexico. And I've had the honor and privilege to be able to say that all of the judges that I've appeared before have had very good judicial temperament. And that made a world of difference in some of the controversial and complicated cases that we brought back then. One individual, well, in addition to all of the district judges in New Mexico, who all have been just excellent judges in my view as far as temperament and the way they handle their courtroom. One example that I can speak to by name would be Judge John Roll of the U.S. District Court in Arizona. Judge Roll was shot and killed not long after our trial in front of him, at the same time that one of the members of the House of Representatives was shot and killed in Arizona, or not shot and killed, but shot and injured in Arizona. Judge Roll was a man who had been known to be a very conservative judge, and we were bringing a civil rights case in front of him. And there was some very controversial and complicated issues that he had to decide. And I think he really exemplified what it means to be a judge with good judicial temperament and be fair and impartial. So I've always sort of looked to him for an example of that.
Well, thank you for honoring his memory today, too. Senator Grassley?
Congratulations to all of you, and we were voting, so I didn't get a chance to hear from you personally. I apologize for that. I'm going to start with Mr. Urias. You urged the New Mexico Supreme Court to prohibit federal law enforcement agencies from enforcing immigration laws in and around the state courthouses. You have also argued against efforts by New Mexico state officials to prohibit foreign drug traffickers from getting driver's licenses. In 2017, you also commended Santa Fe's decision to pass sanctuary city legislation. These questions probably wouldn't be asked of you if you weren't going to be on the court and have to be an impartial judge. So given these positions, can you assure us that if confirmed, you will uphold federal law and serve in impartiality?
Thank you for the question, Senator. Absolutely. Whatever positions I took as an advocate were taken as an advocate on behalf of my clients, and I see the distinction. There could not be something more distinct than the role of between a judge and an advocate. And as a judge, my goal and what I would hopefully try to do throughout my career is to look at every case fairly, impartially, and diligently apply the law to the facts of every case.
Okay. You're also again, for you, sir.
Yes.
You also criticized efforts by the New Mexico Taxation and Revenue Department to stop tax fraud by illegal immigrants. The government challenged thousands of tax returns between 2012 and 2014. This was part of an effort to combat illegal immigrants seeking tax refunds using fraudulent Social Security numbers. You suggested that the government's effort to audit tax returns and prevent fraud was, quote, an act of swindlers, not an act of legitimate state government, end of quote. So I'd like a kind of an explanation of why you described those efforts to protect taxpayers that way.
Thank you for that question as well, Senator. Actually, that case involved what we were asserting in that case on behalf of our clients. That was done also as a lawyer who was advocating on behalf of some state senators who were challenging that law, as well as some permanent legal residents who were caught up in this very broad law that was directed at not immigration or immigrants, but directed on people based on their national origin. And so the state court in that case rightfully applied strict scrutiny and struck that down almost immediately after that. I will say that we worked diligently with opposing side on the tax refund cases those are on the recertification program cases that you referenced. With regard to the tax refund cases, we also asserted claims on behalf of our clients, and that had to do with the fact that the federal government provides people who do not have Social Security numbers a way to file their taxes using I-10 numbers. And so in that case, what was occurring in New Mexico wasn't occurring anywhere else in the country and wasn't done by the IRS itself, and that was withholding tax refunds without a legal basis. So we asserted claims on their behalf. We thankfully were able to resolve that case with the state of New Mexico, and they corrected their ways and understood the way the federal law had been set up so that everyone who works in New Mexico and who pays taxes are eligible for a refund.
Okay. This will have to be my last question. So for the rest of you, you'll get questions from me in writing. Again to you, sir. As a member of the legal panel, you advise ACLU on cases and litigation strategy. 2017, ACLU of New Mexico represented a woman who styled herself as, quote unquote, the high priestess of local Wiccan Coven. In a lawsuit against the town of New Mexico, the lawsuit argued that private citizens had no right to erect a monument of 10 commandments in front of the city hall because the high priestess believed doing so would make her a second-class citizen. Do you still believe that private citizens have no right to raise money to display the 10 commandments if it would offend a witch?
Senator, I don't believe I'm familiar with that case. It probably, if I'm correct on what you are referring, is something that was brought before I was a member of the legal
Let me
panel.
make it easy for you. If
Sure.
you aren't familiar with it,
Yeah.
you can answer that question in writing.
Sounds good, Senator. Thank you.
I congratulate all of you.
Senator Klobuchar.
Very good. Thank you very much, Mr. Chair and Senator Grassley. Thank you to all of you. I was thinking as I heard Mr. Urias about your mother at home, that there's a few senators that have a trouble getting online as well. So hopefully she's on by now. I'm going to focus with all respect to everyone else on my home state nominee here, Judge Menendez. And since 2016, Judge, you've served as magistrate for the District of Minnesota, a position you're selected for by our federal district court judges who have different judicial philosophies, I would say. And as far as I know, every one of them has deep respect for you. How has your experience as a magistrate judge informed your view on the role of a federal district court judge?
Thank you for that question, Senator. I have had the privilege of appearing in front of this same district court over and over again. And as a magistrate judge, I try to act with appropriate judicial temperament and decorum, always applying binding authority to the facts of the case before me, following Supreme Court precedent and Eighth Circuit precedent, also trying to make sure that every litigant that comes before me and every lawyer that comes before me will feel heard, and that I will be prepared to issue an appropriate ruling in the case. I think those same skills are called for if I am fortunate enough to be confirmed to the district court bench.
Very good. And your decisions, I think one of the reasons that you're popular there is that your decisions are reviewed by Minnesota's federal district court judges. I think you've heard over 425 different cases, and that includes judges nominated by Presidents Ford, Reagan, Bush, Clinton, Obama, and Trump. And your decisions have been adopted in full approximately 97% of the time. How do you typically approach a new case, and why do you think these decisions have been adopted by the federal district court?
Thank you, Senator. Every time a new case arises before me, I try to be extremely prepared to hear arguments if there are oral arguments, and then I apply binding precedent. It actually is very often the case that the answers are easy because the authority directly on point applies very cleanly to the facts before me. I also strive to write very thorough but clear opinions that are well organized and can be understood not just by the parties before me and not just by lawyers, but by regular people who might read those opinions to see about the way I'm applying the law. And I think that has led to my reports and recommendations and orders being consistently affirmed by the district court and sometimes by the Eighth Circuit Court of Appeals.
Okay, thank you. Before joining the bench, you served for nearly 20 years helping to represent those who could not afford an attorney. During that time, you worked on hundreds of cases, including one which brought you to the Supreme Court twice for oral arguments. With an 8-1 decision written by Justice Scalia, the court ruled in your client's favor. How were you able to convince Justice Scalia and the majority of the other justices to rule in favor of your client?
Thank you, Senator. Until today, that was actually the scariest thing I'd ever done. And I just endeavored to be very prepared and to do my best on behalf of the individual client that I was representing to advocate effectively to the Supreme Court. Justice Scalia and the other justices of the court, I think, found our position to be the appropriate one in light of the law and issued the decision. But I simply did my very best to be as prepared as possible.
All right. Thank you very much, and thank you to all of you.
Thank you.
And thank you, Judge Menendez. We do our best to make this the scariest moment in everyone's life. Who appears before us? Senator Hawley, following in that tradition.
Thank you, Mr. Chairman. I'll take that as a compliment. Judge Ota, if I could start with you. Let me ask you about some of the comments made by the Lawyers Club of San Diego, and I just want to be sure before I do that, you've been involved extensively with that organization. Is that right? Do I have that right?
Senator Hawley, I was a member of the 15-member board of directors for the Lawyers Club of San Diego, which is a local bar association in San Diego that deals with women's issues. But I have stepped away from that board when I became a sitting judge, just as I've stepped away from all advocacy. And now in my courtroom, I decide all the cases that come before me on the facts and the law only, without regard to previous advocacy positions.
Okay, got it. Thank you. Let me just ask you about some of the comments, some of the statements that the Lawyers Club has made. In a 2020 press release, the Lawyers Club blasted the U.S. Supreme Court decision in Little Sisters of the Poor. That press release said that the decision was, and I'm quoting them now, a devastating blow to women's reproductive justice, end quote, and that the decision perpetuates inequality. That's a quote. Can you explain to me why protecting the religious freedom of this case of a women's group is a devastating blow to women? I mean, tell me the logic behind that statement.
Okay, thank you, Senator. The 15-member board of directors of the Lawyers Club of San Diego issued that statement expressing concern about decreased access to contraceptive care for women. However, as a sitting judge right now, I've set aside all previous advocacy, just as I've walked away from the board, and any cases that come before me.
But I'm sorry to interrupt you. Our time is really limited. Were you a member of the organization, though, at that time in 2020?
Yes, I was a member of the 15-member board of directors.
That issued the press release. Okay, so you issued the press release. You signed off on it. So I want to ask you about that, since that's a statement you signed. Tell me why the Supreme Court's decision in this case, protecting the group the rights of a female religious group, the Catholic Order of Nuns, is a devastating blow to women. I want to understand that statement for the record, so explain that for me.
Thank you, Senator. That statement, again, expressed concern about decreased access for women to contraceptive care. However,
Do you stand by it?
Senator, I regret the extent to which the wording of that statement may give the impression that I would not take religious liberty very seriously in my courtroom. It is a foundational right and one that's enshrined in our Bill of Rights.
Can I just
And
ask you,
in
do you
my-
think that, I'm sorry, I've just got 2 minutes here. I don't want to get you, I want to allow you to explain your views on this case. Do you think that, clearly you thought this decision was wrongly decided. Why? Why is the Supreme Court decision here protecting the rights of this female religious group wrong?
Again, Senator, that was a statement that was issued by the Lawyers Club of San Diego before I was a sitting judge.
But you signed it. We've been over that. So just tell me why you think it was. I mean, these are statements you've made now. So tell me why you think that the Supreme Court decision protecting the rights of this women's order of Catholic nuns was wrongly decided.
As a sitting judge, Senator Hawley, and as a nominee, I would faithfully, fully follow.
Yeah, but that's
all
not what I'm asking you. I'm
applicable-
asking you about your statements that you made recently, I might add. This wasn't an eternity ago. This is recent. These are cases that are from the United States Supreme Court. You've criticized very sharply, I think it's fair to say. Explain to me why you think it was wrong, this outcome in this case, and why you criticized it so sharply.
Senator, what would happen in my courtroom is that I would faithfully apply Supreme Court precedent.
Are you not going to answer my
without-
question? It sounds like to me. Or is this you're declining to answer? So you're not going to say why you issued this statement, why you think the case was wrong.
Senator, I am here to assure you that that precedent, as well as all Supreme Court precedent, would be faithfully followed by me in the courtroom without regard to any previous advocacy statements.
Let me
that-
try something else. Was Brown versus Board rightly decided?
Senator, in general, as a nominee, I would decline to comment on the merits of Supreme Court cases, the parameters or the issues that are still coming before the courts. However, I do make an exception for cases like Brown versus Board of Education, which dealt with de jure racial segregation, and cases like Marbury versus Madison, because those issues are unlikely to come before me. So yes, Senator, Brown versus Board of Education was correctly decided.
Okay, my time has expired. I need to let my colleagues question. I'll have some more questions for the record. I just want to put a marker down here to say that when you've made statements on the record directly criticizing Supreme Court cases in very sharp terms, I might add, I think you need to be prepared to explain why you've done that. I'm not asking you to comment on hypotheticals. I'm asking you to comment on your own statements on law that, frankly, you'll be called upon to apply. And your refusal to do so, to repeatedly answer my questions here today, I think is disturbing, considering you chose to make these statements. And they're very recent statements, and they directly affect your ability to do the job that you're being asked to do. So that gives me a lot of pause. I'll have some more questions for you for the record. Thank you, Mr. Chairman.
Senator Blackburn.
Thank you, Mr. Chairman. Mr. Urias, I want to come to you. Sanctuary cities. When the Santa Fe City Council passed a resolution prohibiting local authorities from sharing information, immigration information with the federal government, you praised this policy as a way for cities to use, and I quote, local resources against threats from the federal government, end quote. So why is the federal enforcement of our nation's immigration law, duly enacted law, a threat?
Thank you, Senator Blackburn. I'm not sure I recall that quote. It's not something that I
Well, then
remember
why don't
saying.
you look it up? Because you're on the record having said that. And we'll be happy to give you that quote in the context, and then we'll expect a written response from you on that, because it's disturbing that someone who wants to be on the federal bench is going to issue a statement calling the laws of this country, the duly enacted laws, a threat by the federal government. So yes or no, do you believe that state and federal partnerships are an unholy alliance? Yes or no?
I do not think that they're on a holy alliance.
You don't, okay? Yes or no? Do you believe that those who seek to protect unborn children are committing acts of violence? Yes or no?
Senator, I would decline to answer that only because those are issues that are still viable.
Okay, no,
in
that's
the
a
court.
position. You have served on the legal panel of the ACLU of New Mexico since 2016, which holds those views. Among other radical positions, this organization has expressed hostile views of conservatives, that's people like me, accusing the Trump administration of racism and white supremacy. So do you support and share the views of your organization?
Senator, I have never been a member of the board of directors of the ACLU in New Mexico. What I am, just for clarification,
You've
is
been on the legal panel. I said the legal panel.
Yes, ma'am. I was asked about 4 years ago to be part of a legal panel, which is a group of people comprised of professors, law professors, members of the disciplinary board.
I understand what it is. I'm asking, and so you can submit for us if you abide by those statements of the ACLU as you served on their legal panel. Judge Menendez, during your investiture in 2016, you delivered a speech where you discussed doing justice while on the bench. During this speech, you made comments that suggest you believe judges should be engaged in advocacy. And I'm quoting you here. I'm also learning that doing justice permits me to give weight to my unique experience, but does not allow them to dictate my decisions, or as perhaps they used to do. In doing justice mandates that I follow the law as it is, not just as I wish it were, something that isn't always easy. In December of that year, you also delivered a speech at the Federal Bar Association luncheon at the Minneapolis Club. In it, you said, "It is so much less clear how to advocate for equal justice now that I'm on the bench. I'm still learning how to use my new role to be an advocate for fairness while being impartial, and still learning when and to what extent seeking fairness is even my job." So what is the role of a judge? Is it to impartially apply the law, or is it to be an advocate for fairness as you perceive fairness to be?
Thank you for that question, Senator. The role of a judge is not to be an advocate. It's to fairly apply the precedent and the law to the cases that come before me. In the courthouse where I've worked my entire career, equal justice under law is emblazoned in big letters.
Let me just say, I have to move on, but it is of concern that you would seek to use your position on the bench as an advocate. Judge Lopez, on one occasion you represented a defendant accused of attempting to re-enter the country illegally after being deported. You argued that it was a reversible error for a trial court to instruct grand jurors to follow the law even if they disagreed with it. Do you believe that a juror may simply decline to indict an otherwise guilty defendant simply because the juror doesn't think the particular conduct at issue should be criminalized?
Thank you, Senator Blackburn. I'm not recollecting the case that you're referring to. However,
we will provide that to you so that you can give us a written response. Do you think that a judge can simply disregard applicable laws if they disagree with those laws?
Under no circumstances, Senator
Under
Blackburn.
no circumstances. Okay, thank you. Judge Oda, my time has expired, but I am going to come to you on this issue of Little Sisters of the Poor for a written response, because your response that you gave to Senator Hawley is insufficient, and we would like to get a little bit more clarity around that. Religious liberty is a bedrock of our nation, and it is important, and so we need some more clarity from you. Thank you all.
Thank you, Senator Blackburn. Senator Klobuchar.
Yes, well, Senator Blackburn's still here. I just wanted to, Senator Menendez, I had a minute left for my original questioning, and I just want to again emphasize how you have heard over 425 different cases as a magistrate. Your decisions have been adopted 97% of the time. by judges appointed by President Trump, by judges appointed by President Reagan. And could you talk about, you were an advocate, of course, you represented clients like most lawyers do in their careers that become judges, how you differentiate that from your role as a magistrate and what I believe will be as a judge?
Thank you, Senator, for that question. From the moment I took the bench, I was actually somewhat surprised at how easy it was to leave behind my role as an advocate and to assume the role of judge, where I have to decide the cases before me based on the facts and the law. Positions that I took as an advocate, my personal beliefs, those things play and can play no role in the decisions I make as a judge.
Again, just for the record, I have talked to a number of our conservative judges who are strong supporters of Judge Menendez. Thank you.
Thank you, Senator Klobuchar. We're on the second roll call on the floor. The only other senator seeking recognition is Senator Cruz and Senator Padilla. So I'm hoping we can still make the roll call. Senator Cruz.
Thank you, Mr. Chairman. Welcome to each of the nominees. Ms. Elliott, when you were endorsing John Curran's nomination to the New Hampshire Circuit Court, you stated that Curran, quote, reads the people, he reads the facts, he's not overly focused on the law, and he understands what the jury might be thinking about, and those same qualities that make him an incredible trial lawyer will make him a fantastic judge. Why do you think it is a beneficial trait in a judge to not be, as you put it, overly focused on the law?
Thank you for the question, Senator Cruz. And I have to say at the outset that that is not what I intended to say. And so I apologize if it's given the impression that I don't think judges need to follow the law. If I were given the honor of a confirmation, obviously, I would follow the precedent faithfully and without any bias. What I intended to say about John Curran, who was then my law partner and is now on the circuit court in New Hampshire, is that he is not overly formal. I didn't mean to suggest that he doesn't follow the law. It's that he doesn't, there are two different types of trial lawyers, as I'm sure you've seen, and some are focused very much so on explaining the law in a dry, kind of borderline pedantic way. And then Attorney Curran was really much more about connecting with the judge and the jury and the parties in the courtroom. And I thought that given what he was nominated to be, which is a circuit court judge doing, small claims and misdemeanor cases, that his ability to connect with the parties in the courtroom would be an asset to the bench.
Okay, thank you. Judge Lopez, before joining the bench, you represented an illegal alien who had re-entered the country after being deported, and you argued that it was reversible error for the trial court to instruct grand jurors to follow the law even if they disagree with it. As a judge, will you instruct jurors and grand jurors to follow the law, even if they disagree with it?
Thank you, Senator Cruz, for that question. Absolutely, I will.
Why then did you argue it was reversible error to do that?
Senator Cruz, I don't recall that case. I don't recall making that argument. As I sit here now, I would not be able to speak to the facts of that case. I can assure you that if I'm fortunate enough to be confirmed, I would do what I've done over the past 3 years as a magistrate judge, which is to faithfully apply the law, and I would instruct jurors to do the same.
Judge Menendez, during your investiture in 2016, you delivered a speech discussing your judicial philosophy. You stated, "I was hoping by now I would have the beginnings of a judicial philosophy, a simple mantra that could help me do this new and difficult job." No such luck, but the verse from Micah that my mom referenced in her invocation is one I keep in my head, maybe because I hear my pastor say it so often. Do justice, love mercy, and walk humbly. Good advice for a judge. Judge, now that you've been on the bench for 5 years, how would you describe your judicial philosophy?
Thank you for that question, Senator. I think it's important, first and foremost, for a judge to apply the law, regardless of their opinions about it, squarely to the facts in the cases that come before them. And that's what I've endeavored to do at every turn, Senator. I would also say that it is important that the parties that come before me feel that they are heard, that I am impartial, and that I am always prepared. I'm not sure I've got a mantra yet, but I am very aware of the role of a judge and the importance of applying precedent.
Judge Ota, you were actively involved with the Lawyers Club as you co-chaired the Reproductive Justice and Women's Advocacy Committee and the Diverse Women's Committee, and you wrote several articles for the organization. In a 2020 press release, the Lawyers Club criticized the U.S. Supreme Court decision in Little Sisters of the Poor versus Pennsylvania. The press release said that the decision to allow religious and moral exemptions to the contraception mandate in the Affordable Care Act was a, quote, devastating blow to women's reproductive justice, and the decision perpetuates inequality. Do you believe that Supreme Court precedent upholding conscience protections and religious or moral exemptions are legitimate and binding on you as a judge?
Senator, thank you for the question. I take the First Amendment rights to free exercise of religious liberty very seriously. It is a foundational right. It's one that's enshrined in the Bill of Rights. And if that issue were to come before me in the courtroom, I would give it the due respect that it is owed. I would faithfully apply all Supreme Court precedent, and I would decide the case before me on the precedent and the facts without regard to previous advocacy positions, without regard to any personal or political beliefs that I may have on the issue.
Did you agree with the Lawyers Club press release blasting the Supreme Court's Little Sisters of the Poor decision?
Senator, the 15-member board of directors of the Lawyers Club of San Diego released that statement. I was on the board of directors at that time.
Did you agree with it?
Senator, that press release issued by the Lawyers Club of San Diego was before I became a sitting judge. Currently, as a sitting judge...
At the time it issued, did you agree with it? That's a yes or no. You either agreed with it or you disagreed with it.
Senator, currently as a sitting judge, I make my decisions.
I'm asking you at the time the press release went out, not today.
Senator, at the time that the press release went out, I was on the board of directors of the Lawyers Club of San Diego that voted to release that press release. However...
Did you agree with it? Did you vote to release it?
Yes, I voted to release it. However, as a sitting judge, my personal views, any previous advocacy statements, don't enter into my courtroom. That would be inappropriate and a violation of the judicial oath that I take very seriously as a sitting judge.
Thank you.
Senator Padilla.
Thank you, Mr. Chair. First question is for Judge Ota. Over the course of a 20-year legal career, you've had the distinguished opportunities to work for judges, to advocate for the state on behalf of consumers, to represent corporate clients, to teach law students as a visiting professor, and most recently, to serve as a judge yourself. So taken all together, you've had a wide exposure to different facets of the law and the legal profession. My question is, how will these diverse legal experiences contribute to the way you approach your work as a federal district court judge?
Thank you for the question, Senator Padilla. I started my legal career not as an advocate, but clerking for Judge Barry Ted Moskowitz in the Southern District of California. From day one, I learned what it means to set aside personal beliefs, political preferences, and concentrate on the law and the facts only, and engage in that most important function of neutral and even-handed adjudication. As an advocate, I zealously represented the people of the state of California, as well as corporation defendants in labor and employment cases. But when I took the oath to become a state court judge, I returned to doing what I learned to do from the very outset of my career, which is to set aside any personal beliefs, political preferences, and decide each case that comes before me on the facts and the law only.
Okay, thank you very much. You anticipated the follow-up question, which was exactly that: what role a judge's personal policy preference may play in the evaluation of the merits of a case before him or her So appreciate the answer. I know it's a very specific question and concern for a lot of members of the committee, and I believe the way you answered should address any questions or concerns about that. Mr. Urias, you've been asked about your personal views and your prior advocacy as well. So let me pose the same question to you. What role should a judge's personal policy play in the evaluation of in the merits of a case before them?
Thank you, Senator. Personal views should never have a place in looking at the cases that are before a judge. So I would never let my personal views or any other views that I might have expressed as an advocate come into play when I'm a federal judge.
Okay, thank you. Ms. Judge Lopez, public defenders play a critical role in our system of justice, functioning as guardians of due process. They serve to ensure that all criminal defendants, regardless of their stature in life or ability to pay, are afforded reasoned counsel and advocacy as the power of the state is brought to bear against them. They put the government to its proof, and in so doing, defend not only individuals, but our constitutional system of government itself. Before becoming a federal magistrate judge, you served for about 11 years as a public defender, and before that, you worked in private practice. Why did you choose to become a public defender, and how has that experience, what does that experience afford you to bring to the bench if confirmed?
Thank you, Senator Padilla, for that question. The ability to assist individuals charged with offenses by adhering to the constitutional rights under the Sixth Amendment was something that was it was a driving force for me. The ability to represent individuals, making certain that their rights were met, was something that was a very rewarding experience for me, and where I spent about 20 years of my life. What it taught me was the importance and the necessity to treat everyone in the judicial system with fairness, with an open mind, and with civility. As an advocate, I utilized those tools in treating and dealing with opposing counsel, as well as with the judges in my case, dealing with probation officers and pretrial services officers and family members and everyone that was a part of the equation. So those are the same tools that I brought with me to the magistrate judge bench, the importance of the role that everyone plays, not just the defense attorney, but everyone. And that has served me well, and those are skills that I will bring with me if fortunate enough to be confirmed.
Okay. Thank you for your response. Mr. Chair, I'd like to enter into the record a letter endorsing Judge Lopez's nomination submitted by a number of federal prosecutors. The letter demonstrates the wide respect that the legal community has for Judge Lopez's intellect, even-handedness, and commitment to the rule of law.
Without objection.
Thank you, Mr. Chair.
Thank you very much, Senator Padilla. Thank you to this panel. This is probably the closest you're going to come to reliving the law school experience, which I look back with fond memories. I would also say to you that there may be questions sent your way in writing. That's been suggested by several of the members here. We're asking those who are doing that to do so by 5 p.m. on Wednesday, November 10th. Is that the answers? That's what the questions are due. Questions are due. And we ask that you respond in a timely fashion as quickly as you can. And before I adjourn, I will just tell you, for what it's worth, one of my favorite Abraham Lincoln quotes. Of course, he was in the political fracas most of his life, and he was accused by one of his opponents of changing his position on an issue. And Lincoln said, "It's true. And I've decided I'd rather be right some of the time than wrong all the time." I've used that, if you can imagine, very many times. I want to thank you all for coming here today, and the Senate Judiciary Committee will stand adjourned.